Welcome back to For the Defense. My name is David Oscar Markus, and in this episode, we get back to our roots. We're going back to criminal defense lawyering, talking about amazing cases, and in this episode, we have Sean Hecker from New York talking about an amazing trial he did out in federal court in San Francisco before Judge Charles Breyer. Judge Breyer was on the show before and spoke a little about this case, so I thought it'd be cool to have my good friend Sean talk about this really amazing case. Sean clerked in the Southern District of New York in the Second Circuit. He was then an assistant defender, worked at Big Law, and is the founder of the amazing firm Hecker Fink. We've tried a case together, and so I know firsthand how great Sean is. Let's get right into it with my friend and truly spectacular lawyer, Sean Hecker, in For the Defense next. All right, well, I'm really excited today. I have my close friend, a brother really, Sean Hecker, who is a true defender. It's back to our original roots on the podcast with Sean. So welcome to the show, Sean.
No, I'm so happy to be here, proud to be here. I feel like it's a sign of your incredible success that you now feel like it's a safe space to even have one of your friends on.
No, it's time that we've done it, and so we have a great case to talk about, Rob Bogucki, what an incredible case. Let's start at the beginning. If you could tell us a little about your client and the charges. They're complicated charges, but really interesting.
It's a fascinating case, and for me, a case study in the dangers of having the government try to use the criminal laws to change conduct in markets that it may not fully understand. So Rob was a senior trader, but ran a trading desk at Barclays, one of the large investment banks. And the government was exploring certain trading that occurred at the bank in connection with a trade that had been done with Hewlett Packard. Amazingly, this is the same transaction at a high level that was the subject of a totally different prosecution out in San Francisco, Judge Charles Breyer, relating to HP's acquisition of the UK company Autonomy. And in this context, the context of this case, what it related to was the fact that in order to buy this UK company, Hewlett Packard needed to be able to acquire British pounds to conclude the transaction. They had to buy the company using British pounds. And they achieved that through the purchase of an option to buy pounds. That transaction was done with Barclays on the other side. And the case, as it played out, ultimately turned on certain trading that Barclays did under Rob Bogucki's direction to hedge risk associated with the unwind of this option, which ended up not being necessary because the price of British pounds went down, the dollar strengthened, and HP was able to get the pounds it needed, not using the option, but just in the open market.
And so tell me a little about your client, Bogucki, and how you came to represent him in a case in San Francisco.
You know, it's interesting. The way in which I met Rob was very fortuitous for me personally. Rob had been represented by a well-regarded lawyer in New York in the context of the bank's own internal investigation. And at some point in that process, it became clear that this wasn't just a bank investigation, wasn't just a regulatory investigation, but the Department of Justice was looking at these issues. And Rob turned to a friend of his who happened to be a corporate real estate partner at my old firm, Boys & Plimpton, and his friend introduced him to me, and we got to talking and hit it off. I'd done a lot of work for traders in different kinds of cases, foreign currency cases, so I was familiar enough with the lingo that Rob didn't think I was completely unteachable, and we kind of went from there.
And so that was your old firm. Congrats on the new firm, which just started. So really great stuff. And when you're at a big firm like that, like Debevoise, it's to represent an individual is different. It doesn't always happen. Was that difficult to get the approval of the firm and those kinds of things, or no issues there?
Well, It was interesting. I mean, Debevoise is a wonderful place, and I was very involved at the firm. I knew that as a business proposition, it was often the case that the highest and best use of partner time was on leading large investigations, representing large institutions, and I did a lot of that work. But it was important to me to maintain an individual defense practice, and the firm was actually quite flexible with me about that. And the reality is, for cases like this one, where you have clients who are indemnified by financial institutions, they can be certainly financially viable cases, even for the large firms. And over time, I think you've seen a lot of large firms taking on individual representations in the right kinds of cases. And in fact, the trial that just happened out in San Francisco involved, not one, but two or three different larger firms.
It's funny because when I first started in private practice, there were very few large firms who would represent an individual in a criminal case. It was almost unheard of. And now every big firm really does it if the money's right.
There's no question about that. It's an incredibly competitive landscape for sure. There are still benefits to being at a boutique, certainly from a conflicts perspective. And one of the things that caused me to want to leave big law and set up a boutique was, in fact, the desire to be more flexible and to be able to take these kinds of cases, get back into court more regularly. And that's been one of the most rewarding aspects of being a boutique.
One of the interesting things that I saw in getting up to speed on your case, Sean, was the debate that we always have about whether to meet with prosecutors, sort of lay out the defense, try to convince them that the case shouldn't be brought. And it seems like in almost every case, there's this conflict. Like, do we go in? Do we show our cards? Do we hold them back? You wanted to show the prosecutors the defense, and they almost, it seemed like, didn't want to meet with you, which was bizarre to me.
Yeah, look, this was a really unusual case. I had another case very recently that had some similarities to it. And notwithstanding that, my efforts in Rob's case at DOJ were entirely fruitless, I have gone back and gone into the government when I thought you would get a fair reception and there was a real possibility of persuading them that their case was wrong, was flawed in some fundamental way. In Rob's case, you're absolutely right. I mean, we were the ones pounding the table to come in to talk to them. We submitted a very detailed white paper. After all, a fraud case, and there were facts that were just wholly inconsistent with the notion of it being a fraud on the counterparty. In this context, actually, HP was the would-be victim, and they really weren't listening, as it turned out. I mean, I think they had made up their mind to pursue the case. There was some really interesting, it became clear later, dynamics that were in play. And this is where, when you're dealing with Main Justice in particular, you have to be really conscious of some of the policy issues that are top of mind at DOJ when you have a potential case. So this was one where the Justice Department was eager to announce to the world that companies that voluntarily disclose potential cases and cooperate fully, including by providing information that would allow the government to charge individuals, would get a declination. And that was a policy that had been instituted at DOJ in FCPA cases sometime earlier, but they wanted to expand it. This was the case that they kind of raced to indict Rob so that they could announce at the ABA White Collar Conference right afterwards that this policy had been expanded. Barclays, in fact, got a declination, and Rob, unfortunately, was collateral damage in what I think was kind of a rush to judgment and a desire to establish a policy that just didn't work because this case wasn't a crime.
Right. Right. And we'll talk in a minute about the future ABA conference where they have to sort of put their tail between their legs, which is, I'm sort of jumping the gun, but it's amazing to me that that's the kind of thing that would motivate them, and they wouldn't even listen for, even when you win a criminal case, just getting charged for Rob is devastating.
Devastating. And I'll say this, it's funny, there was some changeover in the leadership in the unit that brought this case mid-trial, as Judge Breyer started to realize what the problems were with the government case. I reached out back to DOJ, and in one of those hot-headed moments over a weekend at trial, I'd persuaded myself I'd get them to pull the plug kind of midstream, and I really got nowhere. What I was fortunate about in hindsight was that the government didn't actually really listen very carefully to what I was saying. And so they just had a playbook that they were prepared to pursue in trying the case that was unbelievably simplistic, that didn't understand the market, and they didn't shift gears. So I had an experience recently, which was very different, where I went in. This was this case I tried in the fall for a client named Neil Phillips. And in that case, it was with the Southern District of New York. I firmly, profoundly believe in my client's innocence in that case. And I went in with my colleagues and we made a very full-throated innocence proffer on his behalf and brought to the government's attention some facts that I really was persuaded they didn't know when they charged the case. The difference between the DOJ example in Rob's case and the Southern District example in my client Neil Phillips' case is that the Southern District definitely listened and listened very carefully. They actually dismissed part of their case, I think, in response to our presentation, but then did everything they could to kind of undermine the defense they knew we were going to lay out. And in hindsight, I wouldn't make that choice again the same way. I would have saved it. I really believed that they were going to see it our way. They didn't, and they weren't wrong. And it was interesting, just, for the record, like, I'm not the kind of lawyer who goes in and pounds the table and says, I'm going to kick your ass at trial. And in fact, in a case like that, more often the pitch is, look, you guys are really talented trial lawyers. I have no doubt that if you get up in front of a jury and simplify this case, often at the expense of the truth, that there is a very substantial risk that you're going to persuade the jury, but you shouldn't do it because it's not the right thing to do. And that's a very different kind of pitch.
Yeah. And it's funny that you mentioned that, they were able to sort of pivot and address what you did. I mean, that's the big fear that I always have with meeting with them. And so, you do it rarely, and it's a really, really tough decision. And I think one of the toughest that we face is when to go in, when to meet with them, when to show some cards, which cards do you show? There's no right answers on this ever.
No right answers. Very personality driven, very specific to the office you're dealing with, to the prosecutors you're speaking with, to the supervisors for those prosecutors. And it's always a really difficult judgment call. I agree. It's one of the more interesting things that we do. And you can get it wrong. I mean, I think in that case, I may have gotten it wrong, but we'll see. That one could still play out. Right.
And one of the interesting things I saw in Rob's case was this pitch and motions about the statute of limitations. I thought, they blow by the 5 years. You call them out on it. You show them, you file motions. They come up with this sort of BS MLAT defense, which we've seen in lots of cases. And then when you call them out on that and get a hearing, they just supersede with this crazy theory. So what happened there?
So it turns out there were later articles about this. There was something of a whistleblower within the DOJ fraud section, where the fraud section learned in these FCPA cases by necessity that you have to get evidence overseas often takes a long time. You send an MLAT to certain countries, you can wait years. So there's a specific statute that allows them to pursue that evidence and then take the MLAT request that's been made to the foreign government, go to court where whichever judge is overseeing the grand jury investigation and toll the statute of limitations. And you have to identify the potential targets of the investigation for whom you'd be tolling. What the government did in this case, and it turns out I think did in a bunch of other cases, was if there was evidence that in theory they could request overseas and they were worried about the clock running out, they would file the MLAT, toll the statute. It's an ex parte process. And in our case, it was self-evidently pretextual because Barclays had previously, in an unrelated matter, had a guilty plea and an agreement that required them to produce documents to the DOJ upon request anywhere in the world. So the DOJ just had to go to Barclays and ask for the stuff, even if it was based in the UK. And our case did have many facts that were UK based. Some of the trading was done in the UK, for example. But it was completely pretextual. the request was made to toll within days of the statute expiring. Now, as it happens, and as it played out, the judge was great on this. He saw that it was obviously pretextual. He gave us a hearing. He ordered them to produce discovery on that issue. And then, of course, what happened was that they superseded to charge the case under FIREA, which is a 10-year statute. We had anticipated that was how they were going to charge the case at the outset, and were prepared to litigate that issue because the Ninth Circuit hadn't ruled definitively on it. But we lost that issue, and we ultimately gave that up in the context of pursuing our strategy at trial.
Judge Breyer, who was your judge, who, as you say, was terrific, and we'll talk more about him in a sec. We had him on the podcast actually a couple of years ago, and he was just great.
I heard that one. He was great.
Yeah, but one of the things that's so frustrating as a criminal defense lawyer is, and you guys filed great motions to dismiss, but the standard is impossibly high. Cases, less than 1% of 1% of cases get dismissed on a pretrial motion. And so Breyer couldn't really dismiss because all the government has to say is there's factual disputes. But you could see throughout the trial as it goes, as you're reading these transcripts, he realizes what's going on here. Whereas in a civil case, when you get to take discovery and you can take depots and get some answers, judges will dismiss. If this case was a civil case, it may have been dismissed pre-trial, but a criminal case, you're forced to go to trial. It's really crazy how the criminal system's set up like that.
It's absolutely crazy. And the other aspect of that is, in the civil context, whether on a motion to dismiss or a motion for summary judgment, you're going to get rulings on legal issues from the court. You're going to get the standard that's going to be applied. You're going to know what a jury's going to be told plaintiff has to prove in a civil case. Unlike here, right? So in areas where there's legal uncertainty, and Rob Bogucki's case was definitely one, the problem you have is you don't know what the law is going to be or how the jury is going to be charged, what they're going to be told until closing, right before closing. And we were pushing very hard, both in the motion to dismiss and then also in a couple motions that we kind of came up with to try to get clarity from the judge. We thought correctly that it would be really problematic to have opening arguments if the judge didn't clarify what the government had to prove. And the whole issue was that the government was effectively assuming that Barclays and Rob Bogucki owed fiduciary duties to the counterparty on this option trade. And the option trade was a trade that's done pursuant to a standard form contract called an ISDA. The details aren't so important, but it expressly disclaims any fiduciary relationship. And it's not like, the kind of situation where a fiduciary duty can be imposed by law based on kind of unequal bargaining power, anything like that. But the government's whole theory required you to believe that Barclays was under some enhanced duties to the counterparty, treating them like a client as opposed to a counterparty. And the judge got there eventually, but we did not get clarity on that. So the whole problem with the trial, from my perspective, and this, you probably saw this in the transcript of the Rule 29 argument, is the government basically argued that Barclays trading ahead of the options unwind, which was kind of the core transaction at issue, was cheating. It was front running, and it was criminal. And you can't unring that bell. There's no way to undo that. But there should have been clarity among the parties about what the court was ultimately going to tell the jury about what was quintessentially a legal determination. Now, sometimes the fiduciary duty determination is a mix of law and fact, and that's sort of the problem Judge Breyer found himself with here.
So Sean, how do you deal with that, getting ready? Did you guys have, jury consultants and focus groups where you would test different theories in the case, or did you just avoid that?
We did not have a jury consultant in this case. And so we were left with doing it the way, we did it back when we were public defenders. We'd get a room of paralegals together or administrative folks and see what was resonating and what was not. So we did some of that here for sure.
And so how do you figure out how to simplify the case? Because it is a really complicated case. We'll get to your opening in a second, but I saw in your opening you were talking about, car dealerships and things like this. It's coming up with analogies. Is that the idea?
It was the idea. And, we were blessed with a client who was an amazing teacher. actually. By the time we got to trial, Rob had taught all of us enough, and at least conceptually, what was at issue with respect to this option trade. Because one of the issues which Rob would tell you is, when you're trading in connection with an option, you don't necessarily trade the same currency pair even. You might trade other pairs that are highly correlated with it. It's like you're buying apples, you sell pears, like that at that level of generality, we sort of started to get it and tried to come up with analogies that would work. So in that case, yeah, I think we had a Prius dealership because we were in San Francisco. We thought that made sense. I honestly don't know. I mean, one of the great challenges of the white collar criminal trial in cases like this is that the government has the benefit of simplicity, even when it comes at the expense of the truth.
Right,
and that is such a hard thing to undo.
Right, they just say things like greed and cheating and things like that. It's interesting because, as you say, in the white collar area, it's typically the defense that has to get into the weeds to show that it's not what the government's saying. It's really fascinating.
I think it is truly fascinating, and it's why the power and discretion of the prosecutor is at its zenith, in my mind, in these complex cases, because there's a tremendous risk that the jury won't actually understand it, but it seems unseemly or it feels unfair, and they call it cheating. It's really hard to unring those bells.
Did Judge Breyer give you some jury selection in the case? Were you allowed to do some voir dire, or was it all judge driven?
We were, and I don't have a ton of experience with attorney voir dire. We did it once I had a state civil trial actually in Fort Lauderdale where we had a jury voir dire. I should have said at the outset, I tried this case with just this unbelievable team, including one of our mutual friends, Josh Cohen, out in San Francisco, who subsequently has gone to my old firm, Debevoise. And we really were co-counsel on this case with a team of lawyers from my firm. And as you know, from having tried a case together, like, I'm a big believer in teamwork on these cases. So none of what I'm describing, it was just me by any stretch of the imagination. Josh was an unbelievable guide in how to think about attorney voir dire, particularly in Judge Breyer's courtroom. Judge Breyer made explicit with us that we did not have a lot of time, and that we ought to use that time figuring out who can't serve, not trying to really explore defense themes, that it was kind of pointless, and he was going to give us a short leash. And he stuck to that. And he was right. In other words, there were so few jurors who could possibly serve that we were just focused on not avoiding like massive problems. We weren't trying to identify good jurors. We were trying to get rid of obviously difficult ones. And in that courtroom, there's a huge travel range for folks. So we had folks who were there from like Napa, and they were going to spend 3 hours a day commuting and be pissed off. So, right. People like that were out quickly.
In the case you and I tried together, we got a questionnaire, which I think is the most important to get, especially in these white collar cases. Did you get a questionnaire out in San Francisco?
We did get a questionnaire. And, as I sit here now, I don't remember how extensive it was. My instinct is not super extensive. And we got them back, and we did have time to work with them. And they were terrifying. I mean, no one liked big banks.
Right.
No one liked, people who were well off, who worked at those big banks. Hewlett Packard, by contrast, was a relatively local company. It's from Palo Alto, California. And the government was trying to exploit that idea that Hewlett Packard is just a computer company, local-based computer company. One of the things that was really important to us was for folks to understand that Hewlett Packard, they wanted to talk about it like they're selling printers. They had an FX, a foreign currency department within Hewlett Packard. They sell products in almost every country in the world, and they need to hedge the risk of currency fluctuations. They had a team of traders. They were pretty darn sophisticated, which was an important part of the defense theme.
I'll have to say, I did not know that when I was reading the transcripts, and it jumped off the pages to me. And I bet the jurors were surprised to hear that HP has all these traders who are doing exactly the same thing that Barclays is doing.
Yeah, and what was really important was that the the guy who led that group was a very smart, sophisticated guy who would regularly reach out to other Wall Street banks and put them in competition with one another. And I think you saw in some of the testimony, a really important fact for us was the claim was that Barclays wasn't fully forthcoming with HP about what they would do to hedge their own risk if they were to buy back this option they'd previously sold them. But what the evidence ultimately showed as a result of some third-party discovery that we pursued, because the government wasn't pursuing it on its own, was that, in fact, HP was getting bids from other banks, sharing information with other banks, and it wouldn't be hard for the other banks to have known that this particular option was going to unwind and the price was going to move dramatically because of what was already out in the market, not because of what Barclays itself was doing.
And I saw the theme, the government tried to sort of pitch it as David versus Goliath with HP as David, and you guys are countering. It's really two Goliaths going at it.
Absolutely. I mean, Hewlett Packard was a huge company. And as we like to point out, they were quite sophisticated and could get as much assistance on things they didn't understand as they needed. In fact, Wall Street banks kind of fall all over themselves to service an account like HP. And in fact, the guy who was kind of the key point person on their side had kind of called folks into town to explain different things to him. So it wasn't, they were not some helpless mom and pop,
right,
by any stretch.
So Sean, I always like, and we're going to get to the opening and the witnesses in a second, but I always like to sort of talk about the personal side. So you have a family, you're working in New York, obviously, and you have to move to San Francisco, set up the team out there. How far in advance do you head out to San Francisco and set up?
So we had jury selection in advance of starting the trial. So I feel like we were actually out there for probably close to a week before trial started. We set up shop at a hotel and had some, what became kind of a war room space in the hotel. We were well situated. Like we had what we needed for sure: computers, printers, and a team of folks who were there about a week before trial.
I know you guys were making fun of me because when I tried the case with you in New York, I wasn't staying in the greatest place. My partner Marco and I were in a quite an interesting hotel. So you guys were in a better spot.
We were in a better spot in basically in Union Square in San Francisco. I happen to love San Francisco, so that part wasn't so bad. You could take breaks and walk the streets. We had some team trips across the bridge. It was nice as far as these things go, but I don't mean to make light of the difficult work that is trying a case in another place. It's exhausting. You don't have the comforts of home. You don't have your family there to be with you in a time of like incredible stress. On the other hand, they might be happy not to be with you when you're in times of deep stress like that.
I find it easier to try a case out of town sometimes. I mean, to me, it's easier to try because otherwise you feel the sort of pressures of getting home and having dinner with the family and those kind of things. You don't have those pressures when you're there's different pressures, but you don't have those pressures when you're out of town.
I agree. You're pretty single-mindedly focused on the case.
Now,
no question about that.
Are you someone who eats, sleeps, and exercises during trial, or those go to the wayside?
I would say that I've started to sleep more than I used to. I mean, I'm 54. I can't get by on 3 hours a night for weeks on end anymore. I really can't.
I don't know how these guys do it.
I don't try to. I don't either. I've never been one to pretend I can do well on little sleep. So when I'm on trial, I try to get at least 5-6 hours for sure. And my team, who probably will listen to this episode, knows full well that I would often just be like, at midnight, I'm going to bed and I'll wake up and look at outlines or whatever we got to do the next day.
Yeah, you and I had a slightly different schedule when we were in New York together. You would get to sleep a little earlier than I would, but you'd wake up at some crazy hour. You're like a wake up at 4 or 5 during trial day, which is insane to me.
Yeah, well, you just got to get the right number of hours. Doesn't really matter when you get them.
Fair enough. Fair enough. So all right. So let's turn to opening. I want to read a little of your opening because I loved it. It's something we were just talking about. So here's how you start. You say, the government just told you a neatly packaged story of greed and fraud. And let's face it has some natural appeal, right? A big bank engages in a complex scheme in a complicated market in order to make money. Here's the problem with it. It's simply not true. I mean, that's what we were just talking about. The government's just relying on sort of these big themes and makes it kind of appealing to folks.
Look, it's an opening that is almost generic, like that you can use in so many of these white collar cases. In fact, I'm sure we've cribbed from it in subsequent trials because that's just often the dynamic. It's the defense that's trying to bring in the nuance and the context. In these trading cases in particular, you're often talking about cases where the government has snippets of language in chats and texts that sound bad. And traders talk like we would say you'd say they talk like sailors. It speaks of aggression often, and often traders speak in a way as if they can influence the market even when they can't. But that's just how they talk about it. I'm going to pound it. I'm going to drive it down. That's just how they talk.
Yeah.
And you saw, I'm sure, some of the themes had to be like, look, talk is cheap. Actions speak louder than words. And we use themes like that in so many cases, right? And in our case, we had a mix because we had some trader talk that was unhelpful. Very little of it was actually from our client. It was for people who were trading and reporting to Rob. But we also had things that Rob had done and said that were entirely inconsistent with a fraud theory, including negotiating internally with Barclays to offer better pricing to Hewlett Packard than his own team wanted to offer. He thought they should not be greedy. They should do the opposite. They should try to make the counterparty happy with the execution so they come back for more in the future. It was not like we're just going to rip their face off and take as much as we can from them. It was the exact opposite.
And you hit that hard in your opening, and you say a number of times, the government left this out in the story, which I really like. Let me continue with it. This is from the introduction again, which I love. The evidence will show that Robert Bogucki, on behalf of Barclays, helped to execute a big, complicated 6 billion British pound option purchase from HP in exactly the way any competent, skillful, and honest trader would. And it would show that HP got exactly the deal it bargained for, that Barclays and Mr. Bogucki did far better for HP than any other bank would have. And that in the process, HP made hundreds of millions of dollars on this transaction, something you didn't hear about from the government. In short, the evidence will show that Mr. Bogucki is not guilty of the charges the government has leveled against him. He is just plain innocent. Now, that last line, he's just plain innocent, I love it. And I think, you and I have talked about this before. I think you have to come out in a case like this and say your client is innocent, not merely, not guilty or the burden. Any debate about doing that in this case, or that was from the start you were going to do it?
Yeah, not in this one. Not in this one. There was really no need to think that through, because this really was not a case about the government not having enough proof of what they thought. It's that what they thought happened was not a crime, and that they really didn't understand the market, the relationship between the parties, and the way this worked in real life. It's scary. And there have been others like it, are really scary to folks who work in these markets. Because remember, these are heavily regulated markets. There are regulators on site at these institutions like every day. And this was one of those cases where the bank would have been in deep trouble with their regulators if they were not hedging an anticipated transaction of this kind. Now, of course, there are always going to be questions about what you say about that and the transparency with which you say it. But there was a lot of gray area and uncertainty in this market at that time. And subsequently, the banks really changed their practices so that they had much more explicit disclosures to counterparties like, look, let's be clear, we're on the other side of this trade from you. And we reserve the right to trade our own account, including in ways that may change the price for you on our transaction. And if you don't want us to do that, that's fine, but you're going to pay a different price for that service. That's a different deal.
Did the government call someone from HP as a victim witness to say, here's how we were victimized, or did that not happen at the trial?
Oh, it did. It did. It was the person who negotiated the price with Rob Bogucki. And I think it was the examination of that witness that really moved the judge, because the interesting dynamic here was that, there's a way of dealing on Wall Street historically, where there's a little bit of haggling. And in fact, Judge Breyer likened it to a used car salesman who was famous in San Francisco when he was younger, and he joked, that the used car salesman would grab you on the street and tell you you look great in that car, even if you don't look great in that car. Well, in this case, things that HP represented to Barclays were flatly not true. So when HP got pricing from Barclays, they said other banks are better or offering us tighter pricing, better pricing. That was flatly false. And we knew it was false. And it was really interesting that this was fascinating. The HP witness was, I'll just say, not well prepared to testify. We had the notes of a proffer in which I think he'd referred to it as BSing. He was BSing. They put him in the grand jury, and he changed the formulation. He was almost led to say it was kind of like bluffing, like a poker analogy.
Right.
And so we had a lot of fun with that on cross, because he'd once called it BSing, he'd once called it bluffing. It's like, you're basically saying it's not true, but the context of poker suggests an understanding that the game is played in a way where you're allowed to represent you have aces when you have twos. Right. And that's like understood. So Judge Breyer, where he ultimately was really moved, was this idea that how could HP on the one hand be totally comfortable with BSing or bluffing Barclays, and then say, oh, I believed every word that I was told during the course of this transaction, and I relied on all of it.
Right.
It didn't track.
And in reading the witnesses in the government's case, it seemed like, and I think the witness you're talking about is Nesper, right? We'll talk about him because he seemed to be the government star witness. But a lot of the other witnesses seemed by the end of their examinations to be almost defense witnesses. And so, one of the things that I've noticed in trials is a lot of folks, and I hate to say this, but mostly former prosecutors, are afraid to let their clients speak to the defense, or for even the lawyer to tell the defense, here's what they're going to say. But it seems like you may have had a heads up here on what some of these folks were going to say in advance of the trial. And I never understood why criminal defense lawyers aren't willing to share with the folks going to trial what their clients are going to say in the witness box.
Yeah, you and I have spoken about this at some length. And I will say, one of the joys of practice, particularly as you get older and you've been doing it for a while, is you usually know many, if not all, of the counsel who've been brought into the case for other witnesses, and you're repeat players, and you understand the benefits of sharing information. And in this context in particular, and I've made this pitch to young prosecutors going into private practice many times, like, look, your client's going to take the stand. Do you want the cross to go smoothly?
Right.
Or do you want it to be messy? And often, and this was very true in this case, where the government didn't have a cooperating witness who pled guilty. They had a couple bank employees who had participated in the transaction. One of those people had gotten a non-prosecution agreement. The other had not. And neither was going to testify that they thought they had done something wrong. Mm-hmm. So we worked really hard and spoke to their counsel extensively about what we thought we wanted to do on cross-examination in a way that wouldn't be at all confrontational, but would be a very smooth, direct, in the form of leading questions, but where we knew full well how that examination was going to go. And we actually did something really interesting. I'd never had this come up before. I didn't want the government to elicit that one of their witnesses got a non-prosecution agreement. Right. I was very concerned the jury would think that the person needed it. And the lawyer had done a good job getting it. Why not? Although they may not have wanted it to be public for the same reasons. But we moved in limine to preclude the government from offering it, and said, look, we're not challenging this witness's credibility. We're not going to suggest that the witness is lying because they got a deal from the government. So why is it relevant? And the judge agreed. I mean, Judge Breyer was really terrific on issues like this. He called it like he saw it, and there was no reason to put in the non-pros given the cross. And he's like, obviously reserved the right to change his ruling if in fact we did end up having to cross him aggressively.
Fascinating. And that's a big win to be able to keep that out. A lot of judges would have said, I'm going to let the government just do whatever they want to do with the witness. No question. And honestly, it wasn't, it hadn't come up for me before in a context like this,
but now I'm very attuned to it. Like, do I actually want the jury to be told about an agreement like that? Obviously, if someone's pled guilty and they're going to be saying they committed a crime, odds are I'm going to want to explore that at some length. But in a non-prosecution agreement, I don't know. Maybe it was just fuzzy.
Right. And of course, the lawyer's going to try to get a non-pros, even if they think they didn't commit a crime, because the prosecutors here charged your client who didn't commit a crime.
Correct. Absolutely correct.
So one of the things I noticed, and especially during your cross of Nesper, the main HP witness, the star witness, is that Judge Breyer asked a lot of questions. He liked to ask questions, and I've never liked when a judge did that. It always drives me crazy. How did you feel about Judge Breyer right in the middle of your cross asking 4 or 5 questions?
Well, I'm with you. Generally speaking, I'm not a fan, right? You go into it with a plan, there's an order, there's a pacing, and this just interrupts your plan and pacing. You couldn't possibly anticipate that kind of an interruption. I will say here, the way in which Judge Breyer jumped in evidenced his extreme frustration that the witness wasn't giving us straightforward answers. And so in that context, you step back, you let the jury see that like the judge isn't buying what this guy's selling, and you shouldn't either. And you adjust your plan a little bit. So It was fine here. But yes, I agree. And in fact, recently had a trial experience where, the judge questions were decidedly unhelpful, and you're put in the awkward spot at times of even, do I need to try to object to the judge's question, which in our last trial we did unsuccessfully, but sometimes you don't have a choice.
So in front of the
your
jury,
record a little bit. Yeah.
Did you do it in front of the jury, or did you wait till after and tell them?
I was mostly in a watching mode in this trial, but my colleagues did object, and rightly so, and then made a motion for a mistrial because the question, in our view, was so deeply prejudicial and improper. But all of that, unsurprisingly, was denied. But needless to say, we were behind.
Right. So let me ask you about Nesper and just cross in general, because in reading the cross, it was really tight. Lots of just leading yes/no questions and answers. How do you prepare for a cross like the government star witness with Nesper? What do you do in advance, and how do you get ready for something like that? Because it's, again, so complicated, and you have to really boil it down quickly for the jury.
Yeah. Well, a couple of things that I think are important here. Number one is we did a lot of third-party discovery and had received information from other banks that reflected communications with this witness that were very helpful and inconsistent with the government's theory of the case. And for the life of me, I'm not sure how much time the government spent reviewing those documents and preparing their witness to respond to kind of issues that those documents raised. The second thing I'd say is that the DOJ fraud section, I'll pat them on the back, was very good about disclosure. We got disclosure sort of on day one, all the 3,500 material. We had a lot of time to work on this cross, and it was, very carefully calibrated, where we knew where we were going to go if we didn't get what we expected to get, and had a lot to work with because of prior proffer sessions and interviews and grand jury testimony. You don't always have that, of course. Most often in cases like this, it's just an agent that goes in and puts things in through hearsay. So I felt like we had a lot to police the witness with in this case. And I will just say, I don't think he was particularly well prepared. So it was one of those crosses where, you got your rhythm going, you got what you expected to get and thought you could get. And when you didn't get it, it was relatively easy to police, and the judge stepped in at one point. So, I think we had a lot going for us. It's a transcript I'm pretty proud of as crosses go, but you've seen me do crosses that don't work quite as well, and it can be really difficult. And sometimes you don't have any choice but to kind of plow through with someone where you don't feel like you're making headway, but you just can't win the case if you don't discredit the witness, and that can be challenging.
One of the things that SDNY, not this case, but SDNY is doing a lot of, and we saw it in our case, is they're calling these summary witnesses at the end, where they put in like a whole case, timelines and summary charts, and that witness is almost the most important witness. We had it in our case where we went berserk, crazy about being able to do it, and You didn't see that in San Francisco, but you're seeing it a lot more in these white collar cases.
Well, there's no question that in Southern District in particular, it has become a very predictable move. What the government does routinely, I think now, particularly in white collar cases, document cases, is at the end of their case, they call the summary witness who's often an agent who didn't work on the case. So they can't be crossed about what other documents might say or what other witnesses may have said. They just literally say, oh, I have this document. It's dated here on this date, and I've put it on this timeline. And it's a closing deck. And they put it on at the end of their case. So it's effectively a first closing before their actual closing. I think it's a complete abuse of the rule, which is very obviously focused on summarizing voluminous data, not in a trial that may only last, a week or two. And you're talking about emails. That's clearly not what the intent was. And the rule is being amended now. I can't remember the effective date of the new rule. So some of that should come out. And we've talked about this. Nothing stops the defense from trying to do the reciprocal thing and put on a paralegal to put in documents on a timeline. Of course, that requires that you have enough that's helpful to put on said timeline.
Right.
But you taught me something at our trial in crossing that summary witness, and I subsequently used that in my next trial. You can have some fun. I mean, it is something I think that is of interest to the jury to learn that the government has called someone with no knowledge of the case when they often have a case agent sitting at the table who actually spoke to witnesses, reviewed documents, understands the context and you can tell the jury through your examination, isn't it interesting that the government wants someone who knows nothing about this case to put this timeline together? And why is that? And is it because they don't want to have to answer questions about what they excluded? So I think that can be really effective. I mean, I used your outline in my next trial and got some real traction with it. A lot depends on the judge and whether they let you do that kind of thing or how much they let you do. But you ought to be able to do it when the rule is being abused that dramatically.
Right. And it used to be that the government only did this in like bond hearings. They'd call somebody who had no idea about the case, but now they're doing it in trials, which is, I think you're right. It is important to show the jury that they're just really making a game out of it, calling somebody who you can't cross. And when there's somebody sitting right there that does know about the case. So I think there's a lot of fun you can have with it. So Sean, Rule 29 comes around. In reading the Rule 29 argument, you can almost feel how angry, frustrated you were. And what jumped off the page to me was when the prosecutor starts arguing, you feel that frustration from Judge Breyer as well, which was amazing.
Yeah, look, I mean, this was just an epic battle from our perspective that had been going on for a very long time. And it felt like our arguments just had fallen on deaf ears. And we just deeply, profoundly believed that our client should never have been charged and that it was relatively obvious once you understood the market and the context and the contractual documents that the government's theory just didn't work. I did not have much of an outline for that argument. This was not one of those where it was a super detailed presentation at Rule 29. We didn't have a lot of time to do it. We kind of jumped into it. It didn't require me to work up any passion. I was angry. And I felt, like on my high horse a little bit in reading it now, like, oh my God, I'm sure there were people who found it very annoying, but I believed it very, very passionately that they had this wrong. And it was so rewarding. It brought tears to my eyes, literally, when you could tell that Judge Breyer got it. Why this was this huge, I think he called it a massive due process problem.
I was just about to read that quote. So the prosecutor starts arguing and he says, I think you have a massive due process problem, and address why in a criminal case, how a defendant needs to be put on notice that his actions are criminal. I mean, when a Rule 29 argument starts like that, you got to feel pretty good.
We felt pretty good. And what was fascinating was I think the government asked to put in a brief over the weekend and we were supposed to close on the following Monday. So we had this kind of weekend, and I wouldn't say it was from hell because it certainly seemed like the argument had gone well. But needless to say, what judges will often do is let it go to the jury and then maybe fix it. And of course, when we started looking at the issue, it's one of those issues that just doesn't come up so often. You come to the realization quickly, like if the judge doesn't let it go to the jury, the government can't appeal. And if he does and then fixes it, if it comes out the wrong way, then they can. And so you're like, wow, that's counterintuitive at some fundamental level. And we're like, is he going to actually do it? We had to prepare for the closing. So we didn't know till we showed up in court what was going to happen.
See, to me, I never understand. If judges know that the prosecution can't appeal if they do it at the close of the government's case, they should do it more often. Why risk the appeal? They're always saying, well, I'm going to let the jury decide and I can fix it, which is a mistake for them if they don't want to get reversed.
It is, although, as you and I both know, I think that the institutional connection between the court and the U.S. Attorney's offices is such that it is not a small thing. And Judge Breyer said openly that he had never, ever granted an entire Rule 29 motion. In other words, one that was completely dispositive of all the counts in a case. And he'd been on the bench for a very long time. It just does not happen very often because I think that judges would view it as a little bit of, it's going to be perceived poorly within the U.S. Attorney's Office. Now, I will say this is kind of an interesting dynamic in this case. There was a local lawyer in San Francisco, actually from Oakland in the U.S. Attorney's Office, who did come to court. Not someone who I think was regularly in front of Judge Breyer. This was really a DOJ fraud section prosecution with two assistant chiefs of the fraud section who came out to San Francisco to try the case. They were not hometown folks. And in hindsight, I'm sure, well, if I were the DOJ, one of the takeaways I would have had is you really got to partner with the local U.S. Attorney's Office who will know the judge better and where it'll feel more personal if the judge decides to rule in a way that would, toss their case.
But Sean, you must have been dying all weekend because you have to be preparing for a closing. The judge seemed in your favor, but as you say, you never know, especially for something like this. He may wait. He says he's going to announce his ruling in court. You show up Monday morning and he speaks from the bench and he grants it. I mean, what an amazing relief, victory, everything, all the emotions come in.
All the emotions. I mean, there's nothing quite like it. And then you multiply that when you have someone who's had the courage to fight on, deeply, profoundly believing in their innocence, and where you have absolutely no idea what the jury would do in a case like that in particular, where it's so complicated and so hard to understand. And I'll be candid, we were doing our best, no idea where the jury stood on that case. So we were ecstatic, relieved. We were crying. Our client, is among the most generous, kind clients we've had. We get our trial team gets regular texts from him. Amazing. On the anniversary of his acquittal. It's really.
Were you thinking? I mean, he seems like such a good guy, and you believe so much in him. Were you thinking about calling him in the defense case?
Well, sure. We of course always think about it. I know that I think the market's moved a little bit on calling your client in cases like this. We had ready to go an expert who had deep trading experience, who could actually explain why the trading was inconsistent with the theory of trying to move the market against the counterparty. That was pretty compelling. And so we were going to put that on. And we had one other expert we thought we might put on. But we really felt like we'd put in our case through the government's witnesses. And you know better than I, this was one of those where we felt like it had come in as good as it could come in. And if we call our client, it becomes a complete referendum on whether they think he's telling the truth about all of it. And I think Rob would agree. Rob has spoken on a bunch of panels about the case. He's a very entertaining guy. He's a big personality. But the upshot of that is you never know how he would play in a jury in real time, notwithstanding his innocence. And so it wasn't a particularly hard call, I don't think, for him. And he trusted us in terms of the way we were approaching it. Obviously, we didn't ultimately have to make that call.
I love this line from Judge Breyer's order. This was from his oral order. He said, "It is wrong, however, and where I find fault with the government, that they should assume the role of nanny of the FX options market. We're not here, neither the government, its prosecutions, nor the court, to try and create a web of procedures and policies that from perhaps a moral or ethical system make some sense." I just love that.
Look, he was fantastic, and there's no way around that. This result doesn't happen without a judge who really got it and was unafraid, and without casting aspersions at all. There are plenty of judges who just aren't going to go that far in a case like this. But this is part of a theme. There are many cases in the white collar area where you say to yourself, isn't the right answer to the problem the government's identified here like clear regulations, clear rules? If the bank's own policies aren't so clear on this, are we really going to bring a criminal case to send a message that you shouldn't do this? Crazy. It's like, look, guys, we have more tools than criminal law enforcement to police markets. I'm like, if anything, a bit of a progressive around issues of regulation. And I'm a firm believer that rules need to be clear before you start prosecuting people. And I've just had a bunch of cases in the last years where I feel like almost in the competition to bring new, novel prosecutions, you cross the line into markets and areas where all you need to do is have clear rules. These are not folks who can't be persuaded to follow clear rules. That's not what we're talking about. There are people out there who will violate known clear rules, and those often feel like criminal cases, but many of these white collar cases just don't fall into that bucket. And it drives me a little crazy as a lawyer when you see these things like, guys, if the policies at the institution don't answer it clearly, is it really a criminal case? I'd argue no.
Yeah, I mean, it's just, you and I are in the same boat here, and we've been banging the drum on this for a long time. I hope we can get some folks to listen. Hopefully they're listening to the podcast. So last couple things, Sean. So, you get this order Monday morning. You're in San Francisco with your team and the client. I always like to ask, where's the victory party? How do you guys celebrate? How do you do it?
We went directly to a dive bar that we opened at I want to say it was 10:30 in the morning. We drank too much. There was a lot of smiling, a lot of hugging, a lot of crying. It's not a moment I'll ever forget. And I had just this unbelievably tight-knit, great trial team, not just with Josh, but one of his colleagues at his firm at the time, and a team of my colleagues. And we were all just very aligned and very much in it together. And look, I haven't done a trial in a long time where I haven't done it with someone else who's taught me a lot. That was certainly true in the trial you and I did together. And I'm a sponge. I'm not afraid to steal best practices, right? And Josh Cohen is a phenomenal trial lawyer. So I've kind of said to myself, I don't ever actually want to try a case by myself again. It's not as much fun, and I don't learn as much.
I'm the best at stealing. That's what I do for a living in my trials. I love stealing from other folks, and that's what it's all about. Last question, Sean, were you able to speak to the jurors afterwards and find out which way they were leaning, or did it just go away?
Yeah, we didn't. I remember that they were sitting out in the hallway, and I think we just made a judgment what for? It can't get better than this.
Right.
We heard what the judge said. Our client was a free person. It's always tempting to learn something, obviously. But we let it go. And I don't recall whether Judge Breyer actually had instructions around it. I think the government may have to try to get some feedback. It's possible, but I don't know what it was.
Well, Sean Hecker, you're the best. Thank you so much for doing this. What an incredible win, incredible result. And thank you for speaking about it with me.
It was a treat for me. And until our next trial.
One of the difficult things I've found about this podcast is limiting the interview to only about an hour. I could have spoken to Sean about that case all day. It was so fascinating, the ins and outs, making such a complicated case simple for the jury to understand, and getting the judge on board for that important Rule 29 decision. I want to thank Sean for coming on and discussing the case with me. It was fascinating. And next week, we have another great case to talk about with another great former defender, Phil Hubbard. So I look forward to that. Please, if you have listened to this and if you like it, go on, spread the word, leave a review. It's important to get the word out there if we're going to keep this podcast going. Thank you so much for listening, for sending me your emails with comments, and I look forward to continuing to do these interviews next week in For the Defense. Thanks.